Good evening, ladies and gentlemen, and welcome to the Bunker Show. We're coming to you live and direct from the Old Bailey Bunker here beneath the Courts of Justice, and we've got an interesting show for you this evening. But without any further ado, joining me in the bunker this evening is our own ray of sunshine. Here's Helen.
Evening, everyone. Thanks for tuning in. I'll be in the chat room to help you interact with the show. If you've got any questions that you want to ask our guests, type them in there. And really looking forward to listening to what we do tonight.
And also in the bunker with me today, here's Jimmy.
Hi, Fabrice. Hi, Helen. Great to be back here. And we were just discussing earlier that maybe we should just mention before we speak to our guests the current situation with the refugees in Syria is quite a hot topic at the moment, isn't it?
It is, and there's a few people who are being focus points for any help that people want to give any of the refugees. We have Sarah Chalk, and you can always contact us here on Dark City Radio or get in touch with Sarah Chalk if you'd like to do any collections or anything that can help support the situation on the ground. And it's a situation that does seem to have flared up a little in the last week.
Well, I mean, the very emotive and undeniably awful imagery that's been flooding the newspapers. I mean, it's the sort of stuff that is reserved for really pulling the heartstrings as far as the press are concerned.
The press does seem to be in overdrive, and we were speaking about this last week with our guest from The Occupied Sun, who's had a great response over this last week with their action at Stop the Arms Fair. So if you haven't already checked out The Occupied Sun, have a little look on Facebook, and you can see that campaigners so far this week have been stopping the arms traders getting their trucks in using peaceful protest, which will hopefully disrupt the arms trade on the ground in terms of people being able to get the tools that are making people run away from their homes, their workplaces, their families, and also giving us some of the really tragic images that we've seen this week.
Yeah, and would you say it would be unfair to suggest there are some very interesting coincidental happenings all going on at the same time? The parallels are quite interesting. Could you name quite a few one or two that you've come across?
In terms of some of the duplicity that has been hitting some of the front pages with David Cameron and some of the politicians extolling the virtues of England's long tradition of helping those people in need, whilst conveniently overlooking the fact that Great Britain and the Crown interests that Cameron represents have played a great part in that. We had, in 2011, the French Foreign Minister, a gentleman by the name of Roland Dumas, and in a very senior cabinet position in the French government, stating very clearly in 2009 that British officials were going to go into Syria, destabilize the Assad regime, and did France want in on it? And so 6 years later, when we have millions of displaced people, hundreds of thousands of dead, many refugees wanting to leave such a dangerous place, in the 6 years intervening, we've had a very great role in arming a number of parties in the country, which is never a good thing for living prosperity and helping people live and work in peace.
I mean, that's the sick irony of the situation, isn't it? We're arming them and then we're bombing them. It seems to me that, how do you actually help Syrians who are fleeing from bombing by bombing them?
It's a very, very, very strange logic, and in terms of the arms fair that's happening in London this week, it's a good way of showing that you don't trust that logic. Tony Blair once asked us to trust him with weapons of mass destruction and going into Iraq, and with British citizens, so-called, being drone striked in Libya. And I've had a little look into the legal situation with the drone strikes in Syria. And really, it's a very, very, very flimsy basis. I'm very grateful once again this week to craigmurray.org and his revelations on the legal advice. And I'm going to paraphrase some of his reports that you can get on his website today. The government based its decision to execute by drone 2 British men in Syria on legal opinion from the Attorney General for England and Wales, Jeremy Wright, a politician, MP and Cabinet Minister. But Wright's legal knowledge comes from an undistinguished first degree from Exeter and a short career as a criminal defence barrister in Birmingham. His knowledge of public international law is virtually nil. And there's no pretense of consulting the Scottish legal system. The only legal opinion is from the Attorney General of England and Wales, who is also an honorary Advocate General for Northern Ireland. But Scotland has an entirely different legal system, and it seems as though it's totally unrepresented. But Jeremy Wright's role is merely more a cipher, a charade, a mouthpiece. The government employs in the Foreign and Commonwealth Office a dozen of the most distinguished public international lawyers in the world. When the Attorney General's office needs an opinion on public international law, they ask the Commonwealth for the opinion, and he generally signs it. The only known occasion when this didn't happen was the Iraq War, where unanimously the Attorney General, Lord Goldsmith, was advised that to invade Iraq was illegal. Jack Straw asked the Attorney General to dismiss the Foreign and Commonwealth Office Chief Legal Advisor, Sir Michael Wood, but Goldsmith refused. Instead, Blair sent Goldsmith to Washington, where the opinion was written for him to sign by George Bush's lawyers. I know this sounds incredible, but it's absolutely true. Sir Michael Wood's deputy, Elizabeth Williamshurst, resigned in protest. In consequence, it was decided that for the first time ever, the chief legal advisor to the Foreign and Commonwealth Office to be appointed not from within their legal advisors, who had all declared the war on Iraq to be illegal, but from outside. They found a distinguished public international lawyer who was prepared to argue that the war on Iraq was legal. And from that very small field, they turned to Benjamin Netanyahu's favourite lawyer, Daniel Bethlehem. Daniel Bethlehem represented Israel in relation to Gaza, where he argued that it was a legitimate self-defense to construct a vast wall building on illegally occupied land and surrounding and isolating a lot of Palestinian communities, in effect turning them into large prisons. So it was David Bethlehem who developed, through his work for Israel, a doctrine of the right of states to use preemptive self-defense, a doctrine which would not be accepted by the vast majority of public international lawyers. He clinched his appointment by Blair with presenting a memorandum to the House of Commons Foreign Affairs Committee outlining this doctrine. And so a key sentence in his memorandum is, it must be the right that states are able to act in self-defense in circumstances where there is evidence of further imminent attacks by terrorist groups, even if there is no specific evidence where such attacks will take place or the precise nature of the attack. So there is a fundamental flaw in this argument. How could you be certain that an attack is imminent if you are not certain where or what it is? How can we mildly imagine a scenario where the government know of an imminent attack, but not where or what it is? How could killing somebody in Syria stop that attack in the UK? If a team were active, armed, and in the course of an operation in the UK, which is needed for imminent, how would killing an individual in Syria prevent them from going through with it? It simply does not add up as a practical scenario. And interestingly, Daniel Bethlehem does not pretend this is accepted international law, but specifically states the concept of what constitutes an imminent armed attack will develop to meet new circumstances and new threats. He is attempting to develop the concept of imminent beyond any natural interpretation of the word imminent.
Man, that's just a flimsy premise to come at, for any justification for any preemptive strike. I mean, where's the public mandate? That's just absolutely ridiculous.
Well, it does seem that the language in the Attorney General and his legal advice of the legality of killing British citizens in another country without any due process, without any trial, which is an execution. It seems that the legal basis for that is quite flawed, and it's very difficult, as you mentioned earlier, when you see tragic scenes of people's lives being ripped apart, to actually go and have a look at the cold, hard legal situation where people can, on the strength of an interpretation of imminent, we heard 45 minutes, and it would be imminent that Saddam Hussein could attack us with chemical weapons.
I mean, could technically not in my name be used as a legal argument?
In terms of the more resistance that people can build up, the more questions that people can ask about the nature of that legal advice to any officials, any public bodies, any recordings of that, then that surely helps draw the attention to where it's needed, which is not making excuses to go and burn women and children and men out their homes and workplaces.
Yeah, I mean, it just feels like it's coming to a time where we need some sort of kind of braking mechanism for such mad actions. It's ridiculous.
Well, there are a number of groups which are throughout the country, constitutional groups, which are aware that the legal system in some places, or in a number of places, is no longer functioning, and that sometimes public groups may have to step into those roles. So if groups can obtain all the evidence and necessary second opinions to put before a public body with the oversight and the general approval of the public, then as a public service, it seems that very few people are questioning the validity of some of those legal opinions.
I mean, just in my humble opinion, I think before a nation goes to war, it should be put up to referendum.
Well, there is a call. I believe David Cameron today has requested that there be a vote on further action in Syria, and if that is the case, then the more people email and contact their members of parliament, then the less likely they are to approve such a course of action. And that's like the people who are by the Excel Centre in London today, stopping their arms sales, doing that. The people who do send emails asking those pertinent questions, those are the people who get change. And it does seem that the legal system is coming into question more and more. And we have our guests with us. We have Legalland, No State Project UK regular, Vin James. Hi, Vin.
Hello, Fabrice, and hello, everyone. Thanks for having me back on again.
Hi, Vin.
Would you like to add anything on the Attorney General's so-called legal opinion on why it's okay to execute people in other countries?
Where'd you start? I mean, it's an issue of whenever they claim anything to be a legal opinion, they try to use that word in a sense of obviously giving it some sort of legitimacy and all that, because by implying that it's a legal opinion, or they're doing something legally, it's been through all the checks and balances, and it's been peer reviewed or whatever, and it's gone through some sort of process for these people to justify what they're doing. And the truth of the matter is, it is completely arbitrary. They're looking for an excuse to go out and murder people. And the truth is about this Syrian crisis is that it's such a complicated war. I mean, there's no one side can claim to be the better of the two, and both sides are happily murdering civilians. They couldn't care less. It's all about a fight for power as usual, which is what these things are usually about. But it's also, something I was reading about Syria was they reckon that actually this wasn't the people rising up against the Assad regime. It was more against people having problems regarding a 6-year drought that had taken place. And resources was dwindling. Their own natural resources were dwindling. The Syrian cities were getting flooded with Iraqi refugees, and that was putting such a strain on the cities and towns that they just couldn't cope, and it just ended up imploding in on itself. So this seems to be a lot of what it's about. And most wars are usually about some sort of natural resource, and it would appear this war has come about regarding possibly those elements, a drought and refugees that are basically hitting them from other parts of the Middle East and all that as well. And basically, what you've got then is that the politicians are just using this as another political tool to try and gain control of another part of the world, which is we always knew that Syria was going to kick off one way or another, especially after the Iraq war. They were just looking for that excuse, that trigger to kick a war off over there. Whereas before,
so it seemed that they must have needed irrigation and water facilities and the equipment to deal with a drought much more than they needed support for an uprising.
Exactly, yeah. That's what it seems as is what was actually going on, and this is why it's difficult to understand why a war just suddenly kicked off. And we only get to hear what the obviously the media wants us to know about. It's very difficult to get to the truth and get to the bottom of many of these issues that supposedly kick these wars off. But usually once the Western governments start getting involved, in England and America and such, they're usually after trying to control that part of the world. They're trying to get a government in there that's probably going to be friendly to them, such as the same way that we have with the UK government and the American government, if you like, US government in regards to Israel. And this is what they're after. They're just looking to
Saudi Arabia.
Maybe there's oil involved in this. Maybe there's other natural resources thereafter, such as mining and whatever. But
gas pipelines as well.
Quite possibly. Yeah. So a lot, whatever the real cause is, this is what politicians do all the time, and they're just trying to use this as another excuse to go out there to control another part of the world, and they have to create a boogeyman. So, no doubt. I mean, I'm believe it or not, I'm not really up on this. I'm not really very very well read of this, or I really understand a lot about this Syrian crisis. But pound for pound, I think I'm probably correct in saying that it's obviously governments wanting to control that particular part of the world, that area, for natural resources, and that it's probably more an issue of I've lost my chain of thought there, but sorry, go on.
I don't know about you, Vin, but the thing that's really sparked my curiosity is like the timing of the whole thing. And it's not as if this is a new crisis, because suddenly the media has attached itself. And where were they right at the beginning of the situation, where they could have been headed off?
The country's fallen to bits, and they couldn't care less. But like I said, they've brought a boogeyman in. Now, no doubt, they're probably saying that Syria is harbouring terrorists. ISIS has moved in there. Probably so has Al Qaeda. Like I say, I don't know nothing about this.
It'll be interesting to see how the press narrative develops. I was going to ask Gary, what's the media take on the Syria situation over your side of there at the Big Pond? And do you have any opinion on the Syria situation as we've discussed so far?
I'm sorry. I'm afraid I'm a bit involved in work this week and haven't really poked my head out and to see what the media is really saying.
Okay.
I'll reserve my opinion other than to say I certainly hope that the ethics of the situation becomes a little bit more important, hopefully, than the legalities of it. But
sometimes the focus on some of the legalities can kind of, especially with some of the things that we discuss here. And I found that American Special Forces are operating in 85 different countries around the world without congressional oversight. And we seem like we have a similar situation developing here, where we've had reports of SAS soldiers dressing up as ISIS, doing operations in Syria without parliamentary approval. but yet with a legal opinion of the Attorney General. And as we've seen in a number of ways, practically, when we've gone into court, that the legal system isn't always doing what it says on the tin, in terms of that they have an agenda, and when they come for you personally, it can be very hard to get through some of that. I think, as Vin was saying earlier, some of that implied responsibility, that because it comes with the stamp legal or official, that it has extra validity.
Well, I mean, there's absolutely no use, Fabrice, in Parliament waving up its hands, screaming refugee crisis after 5 years ago, when it was first passed through Commons and put down. It was mentioned there would be a refugee crisis. It's stupid.
Yeah, that was 2 years ago.
Sorry, 2 years ago.
Yeah, I mean, in terms of Gary, thank you for joining us. We've had you on before when we've been talking about preparing for court. Now, you've been doing a little bit more work helping people with that recently, and there's also been some interesting resources for people to get the hang of different options that are open to you when you do go into court. So could you tell us a little bit about why you find role-playing quite useful when people go to court?
Well, one of the hardest things for all of us to stop doing in court settings is to stop sabotaging our own interests. And one of the things we do most is adopt the terminology that our opposition is proposing, things like talking about their case and things like talking about your defense. So role play helps us to get unprogrammed from standard language.
Because I did that a couple of weeks ago. We had Pavla, who was going through her first case, and I would say that they entered a plea on her behalf, which is using their language, but is very, very far from what I was attempting to explain.
Yeah. One of my that's one of my peeves is the on my behalf, and it's common language here as well. And the judge is proclaiming it, and the prosecutor is proclaiming it, that they're doing things on your behalf or to assist you or to protect your rights and things like that. And when we do it, if it's distinctly against our interests, for example, if they enter a plea of not guilty, supposedly on your behalf, while you're trying instead to challenge or demur or to challenge if they have a case or get some clarifications from them, they're doing so to subvert what you're trying to do. So they're actually, it's to your detriment what they're trying to do, and they're trying to put words into your mouth to your detriment. So when you go in and you say, well, the judge had entered a plea on my behalf, you're sabotaging your own point that what was done isn't on your behalf. It isn't to benefit you. It is a detriment. And so we have all these common phrases like that trip us up and cause us to say the opposite of what we mean.
Because one thing that we have looked at is the intention to plead responsible if you're shown that it's a valid charge, a valid injury, and that is quite an interesting one when that's put up against the kind of process that wishes to enter a plea, whether you like it or not, on their behalf. So what use do you think it has by going in and saying, do I have the right to plead guilty? The interesting...
Oh, I'm sorry. There's a slight delay. You'll forgive me. The interesting effect it has where where you're at the outset of what you're being charged. They're trying to explain to you that you're charged, and they supposedly have some kind of an obligation to inform you of the cause and nature. Now, they'll readily admit that they have that obligation to inform you of the cause and nature, generally here. But as soon as you go on to clarifying what the actual cause and nature is, especially if the questions are embarrassing, you'll find that they don't want to actually own up to that promise. So you're leveraging the fact that they proclaim that you have a right to know to be informed of the cause and nature, but as soon as you ask a clarifying question, they'll do everything they can to stop you from asking it, or stopping you from being able to ask it, or to get you to abandon those embarrassing questions. And we see it over and over.
And examples of some of those embarrassing questions would be, what jurisdiction do you have to demand my presence here today? Or what evidence do you have?
Certainly, yeah. What justification for dragging me in? Someone who's presumably innocent shouldn't be dragged through a court, is a thought. So how can you be presuming me innocent and treating me as not innocent? All those little dichotomies that they have, all those double thinks that are going on in a court. You point them out one by one, and you clarify, how is it true that I'm being presumed innocent, but I'm not being presumed innocent of jurisdiction? No evidence is being required of the accuser to use the
I've asked that. I've asked that in court when they've been entering a plea that I haven't made, shall we say, and the answer I ended up being given is that they had to put a plea in to generate their case file, or they wouldn't have a case file. And it was just absolutely absurd. It's like, no, actually, this is a case. This is me. Can you talk to me and answer my questions, and then you can put my plea in. And anyway, it was. They said to me, we have to put one in, and the only one we can put in is that you're pleading not guilty, and that you can have it struck before the trial starts, or at the case management hearing.
But they were trying to dodge the questions you were asking. They were trying to stop informing you.
Yeah, they were avoiding because I've been asking the questions of the prosecution for a long time before we ever got to that stage. So it was like, why can't somebody answer the questions?
Yeah, and usually the question at hand is a simple yes or no question if you've constructed things well. And it's supposedly something you have a quote unquote right to know, and yet they're avoiding answering a simple question by going on at length about some ceremonial issue or some paperwork issue. But they're affecting your status, I guess. They're affecting their ability to answer your question because of a form somewhere, because of a folder, which is a little absurd.
And because they could actually do it properly if they'd answer the questions, but of course they don't want to do that, so they shout at you instead.
So what do you feel the judge's role is at a plea hearing?
To move things along quickly, one way or the other. And I mean, the public relations would be that he's there to protect your rights and to protect the prosecutor's rights, I suppose, as well. But I guess unofficially, what we tend to see the judges doing is to identify embarrassing questions that the prosecutor hasn't or won't be answering, or that makes that points out some trouble with the arraignment itself or the plea hearing or whatever it be, and squash them and get them abandoned and get us to abandon them in some form.
Yeah, because I guess when you are at a plea hearing, you have the option to plead not guilty, the option to plead guilty, and there's, I guess, also the option to be informed of the cause and nature of what's taking place. And I've seen you sort of balance up some of those 3 points when they seem to be doing what they attempted to do in Helen's case, which was get a plea entered. which, as you say, if the judge's role is to move along and get as many pleas entered as possible during his sitting. How do you think? So. Yeah, how do you think awareness of those three things can help?
I'm sorry, are you talking about the 1, 2, 3 or another three things?
Yeah, actually, the 1, 2, 3 would be a good time to go through.
All right. So there's 3 points, and I've canonized them, I guess, but certainly not original thoughts. But 3 segues, I suppose you call it, if they give you some excuses or some speech to try to get you to abandon a question and to move on. 3 segues I like to point out to get back to the question at hand, which is unanswered. That's the whole point. So you've asked a simple question, and you've gotten a non-responsive dump of whatever, and so the 3 I've identified as number 1 is the intent that you have to plead guilty. It should a case actually be clarified, the kind of good nature or the good faith attempts that you're supposed, that you should be there to do if a valid case or ethical case or whatever it be is presented and clarified, that you'd want to avoid a trial altogether, that you'd be pursuing a guilty plea. So your intent to plead guilty, if you are guilty, is the number 1 segue to get back to talking about something other than moving on to trial. Talk about the question at hand, the informing. That would be number 1. Number 2 is the gun in the room. The fact that you're there under threats of violence. An innocent person, presumably according to them, and you probably know yourself to be innocent, but the gun in the room is that there is an escalation of force that will get you to comply. You're not there because of some feeling of civic duty. You're there because if the alternative is that they'd escalate violence to the point where you had no choice.
So they might get a warrant out, and they might come and get bailiffs to come and try and take your possessions, or they might throw you in a cage. Okay, so it's drawing reference to that. And the number 3?
Number 3 is the prosecutor's failure, or the accuser's failure. I don't know about terminology in different areas, but the accuser's failure to clarify himself. So we left some vague points, and you're asking a question in order to clear up that vagueness. So the questions we have are all clarifications, and if the prosecutor fails to clarify himself, he's failing to prosecute. He's failing to state a case. He's failing to make his case. He's failing to do what he needs to do to get a point of arraignment or plea.
So, for example, if one question we ask is, how does whichever piece of legislation, the Road Traffic Act, the Misuse of Drugs Act, how does this legislation apply to me, and what evidence has the prosecutor presented that does apply? And sometimes we hear it's the law of the land; it applies to everybody in the realm or everybody in the state, or and what makes you think you're above the law, which is often a way of trying to bounce it back to you. And whereas with your 1, 2, 3, it's quite easy to deflect that back. In terms of, I've heard you use objection, point of clarification, and that's a useful way. Would you be able to explain some of the use of that?
Okay, so the primary objection in the case where you're being informed, you're leveraging the supposed right to be informed of the cause and nature of the proceedings, is the point of clarification. Is you're pointing out that something is vague. It could mean one of several things, and in order for you to kind of understand how things are going and where you're at the moment, that needs to be clarified. And one of the clarifications that is best is the more in the abstract you think this isn't how it would come out, but is this based upon evidence? Are you acting upon evidence, or are you just, supposing? So you ask them, has the accuser provided any evidence of whatever it is that's at issue at the time, jurisdiction, that the codes apply to you, or that there's, jurisdiction to be pulling you in for a plea. Whatever the issue at hand is, you're clarifying, is that accusation based upon evidence, or is it just a supposition? And that's a valid clarification, and not one they want to answer.
Hi, Gary. During your experience, have you ever had an answer at all to that question? Has anybody attempted to come up with an answer?
So the questions I usually frame as a yes/no questions. I get baby steps, small confessions, and generally they're one where a yes answer or a no answer is rather a detriment to them, or shows dishonesty for the judge or prosecutor. That's the ideal way to construct a question. So very rare, except in some softball initial questions like, do I have the right to be informed of the cause and nature of these proceedings? I'll get a yes for that, because it's solid public relations that they have, to the accused has the right to be informed, The questions, once you get onto the question of, has the prosecutor provided any evidence of jurisdiction, they probably will say yes, and then kind of recant it a little bit in saying, well, this paperwork is evidence. And it's like, well, I'm sorry, I've been through this paperwork. Could you point to the evidence? And then they won't, because they fibbed, because they were being general. And they just supposing that in the ticket or in the summons or whatever, there was mention of evidence when they're not really referring to anything.
Yeah, and that's one that we often see is when you ask that yes/no question, the bench can often reply, they filed everything that they need to file, or that they've filled out all the paperwork that they've had to, and it's written there on the ticket, the Road Traffic Act or the Misuse of Drugs Act or whatever particular legislation that they choose to say or imply is that you have an obligation to adhere to, but they don't actually provide any evidence. And I guess using those objection point of clarification, do you have that evidence and when? And Vin, have you got anything to add to your experience of the 1, 2, 3 and things like that in court?
Yeah, I just wanted to ask Gary what his thoughts are on explaining to people about the nature and cause of what we're asking for, because a lot of people seem to get a little confused with that. I think with the cause, it's that's an easier one to explain. But in regards to when you're asking for the nature of the accusations against you, what would be? How would you try and explain that to people?
I've been chewing on that one for a few years, and the best I have to understand it is that the cause is everything physically that occurred that's relevant to what you're accused of. Everything up to now is causal to where you're at. So the cause of the accusation. And it's a manifest thing. I'm not talking about a legal abstraction. I'm talking about physical cause. And then the nature of the proceedings is how things are going to progress in a discourse type sense. What are the rules of back and forth? What is due process? And how is due process going to be addressed? So the nature of the proceedings are things like, what is stare decisis and how is stare decisis going to impact this, these proceedings? If legalities and ethics are in conflict, which one's going to be taken as superior? Things that we should be asking about how we're going to proceed, rather than just leaving it to the judge's discretion.
Could you explain just a little bit stare decisis for us?
There's a notion that the legal decisions will hold kind of steady to their own even errors, so that right, wrong, or indifferent, that there's some continuity to legal decisions or how courts are going to decide things, but that politely shoved aside ethics and rightness. So you've just been told, if it came up. So when they mention stare decisis, they're basically setting aside principles of right and wrong in order to say we're going to hold to the errors or to the judgments we've made in the past. not a very good concept, not a very good argument. It's a bit like saying we're going to stay wrong where we wish to stay wrong.
And even despite the wish to stay wrong, like it's more to appease the bureaucracy of it all.
Fair enough. There's a lot of politics involved.
Yeah. It's just simpler not to throw a spanner in the works.
Certainly. And the other side of the argument is they say they want consistency in rulings, but how about ethics in rulings being the primary motivation, right?
That's it. Yeah. Be consistently wrong about something, that doesn't make it right. That's the point, isn't it?
Right.
And especially when you make a legitimate challenge to work out how your obligation is created, if it's an arbitrary piece of legislation. Because if there isn't evidence showing that, but yet, as we often hear, it's the law of the land and it applies to everybody. And that's obviously a fallacy without any evidence to show that it does.
Yeah, non sequitur to be.
Yeah. And
they've just replaced one non sequitur with another. I'm sorry. Go on.
I was going to say, do you think that the public's ability to understand that and have people in court when they are showing that has an impact in the way the legal system functions when they come across people who are asking those kind of questions?
Yeah, there's a bit of two troubles. Is the one that most people who are accused can't really identify logical fallacies, and as a result don't know to object. And the other side is that there's an intimidation at work where they're afraid to object. Things that you wouldn't let somebody do in a pub in accusing you. If you have some judge up there and well, here some armed guards nearby, but bailiffs in either event, you're generally too intimidated to counter what a judge just said effectively. Very, very common to be too afraid.
I mean, we've had a number of cases in this country of people, and some of them have been, shoplifting to a matter of £2 or £3, where people have also been intimidated by the costs that incur and have pleaded guilty just out of the intimidation of what may happen to them in terms of financial censure, or even, the prospect of, a worse censure than that, imprisonment.
So over there, an innocent person who's accused has to fear costs of defending himself. Is that what I'm
Yeah, absolutely
hearing?
They do, yes. I mean, even down to people who've stolen food from a skip that's been thrown away, being faced with huge costs to defend themselves and not knowing what the outcome of that's going to be. It's a real threat on people. Another thing I wanted to mention from the chat room, actually, that was brought up earlier is the fact that in our plea hearings, it's not a court of record. We're not allowed to record, and they don't record. And quite a few, there's been a few groups of people, including John Patterson and his crew, that have been going out and filming filming up to the point where they're forcefully stopped to film, and they sort of say, "Do you think that's a good idea?" And I was just throwing it out there. Do you think people should be turning up and trying to insist for a court of record?
Well, there's two concepts at play here. One is that it's recorded, that there's some evidence of what actually occurred to help counter lies being made later or adjustments being made later. And the other is the court of record concept, which is a little bit more than that. It plays into different legal constructions and due process issues. But the recording issue is one we have as well. The idea that they're trying to be more and more secretive now that it's easier and easier to publicize wrongdoing. They're clamping down on recordings being made here too. They're very powerful. We're seeing more and more recordings of police being done, and as a result, there's a huge backlash against police brutalities. And next up is the judge brutalities.
It's in the murk of the no recordings where you get the on my behalf bits. Hey.
And, in terms of what you're saying about cop blocking is a really interesting thing, because if people are acting in accordance with due process, with accordance with the ethics that their public relations